have a TV near my PVC CJ?
No, sir, I don't. But I'm not understanding why that's a difficulty because.
No, apparently, what Mr. Nash is saying, if we do the PowerPoint, it may.
I know what Mr. Nash is saying, Chairman, and last year we didn't have a PowerPoint and having people online. So there needed to have been some conversation with the relevant technical persons to overcome the matter. Is Mr. Brown available, Mr. Nash? Perhaps you could ask him to come down into the chambers because he had a solution for my committee. And it worked.
Okay. There might be a slight interruption, Senator Golden Campbell, but you will be able to but the interaction with you will have to, once the PowerPoint is finished, then you will be able to interact. But
Mr. Chairman, I appreciate what you're saying. Right. I understand, and I'm going to be cooperative and accommodated. Right. Today, because that's really my only obligation. I must register, though, that I think it is absolutely unacceptable that this matter is arising in a committee meeting when we have agreed some time ago that we would have a hybrid meeting. And this matter has been resolved by the Parliament before Mr. Nash simply needs to do the requisite due diligence and get the appropriate technical person to opine and fix it. I had a 6-month meeting with a hybrid meeting and people giving presentations. And that was just last year. And I was told the same nonsense at the beginning of my committee and the matter was resolved.
No, there's no doubt that for this evening you will be able to share the screen, but the interaction might be not possible.
And I'm indicating to you, Chairman, that right. I'm going to cooperate with you
no problem.
As chair. In the matter, but I am registering
no, we're going to try
that the matter has not been appropriately dealt with by the Parliament and needs to be. And the Parliament had sufficient warning from me 2 weeks ago as to how to resolve it.
Okay. All right. We're going to proceed. Mr. Nash, where is Mr. Nash? Who is there from the IT? We're going to do the PowerPoint now. All right. We're going to proceed with the PowerPoint and then afterwards we reconnect with Senator Golden Campbell, but she will be able to hear and see. Are you ready? I know they'll be on. All right, so the Senator will be on and hear you, but you won't see her on the screen. Okay, so proceed. You ready? Who's putting it on? Who's putting on the? Put it on. They're ready. Huh? Yes, but tell them to put it on. They want to begin.
Mr. Chairman, are you still hearing me?
I'm hearing this still, but
just very quickly, I'm just recalling now the solution that was found, and it was that the presenters presented from their own device while the Parliament projected the meeting in hybrid format on the screen. So we were then able to see both the screen and have the hybrid committee members present.
Okay.
And I'm pretty sure Mr. Brown can replicate that.
So I think for the future, if that happens again, we must, Mr. Nash, if somebody wants to present a PowerPoint, they can do it from their screen rather than the Parliament. That would allow several. No, they're going to. Is it ready now, the PowerPoint? You could do it from your computer there. If you, Mr. Nash, could you give it? Mr. Nash, you can go straight from your computer. It will come on the screen. You have it, you give her the link. It's going to come on. It's coming on shortly. Mr. Nash, could you help them, please? You got the link, Ms. Gold? Huh?
Chairman, is it possible for us to get the IT person in the chamber to assist?
No, we are going to do what you suggested earlier. So, Ms. Gold, Minister of Education, will come on from her
I'm not
computer.
hearing you so well, Chairman.
Ms. Gordon, we are giving Ms. Gordon the link that you have, so she will be able to come on and you will be able to see everything.
is used as a last resort. Now moving into the analysis of the substantive errors and related provisions. Change slide, please. Slide 4. Section 2.1, which is the interpretation section, it treats with the definition for child diversion. Child diversion means a child appropriate process of determining the responsibility and the treatment of a child in conflict with the law without resorting to formal adjudication by a court. And we have highlighted without resorting to formal adjudication by a court. So the scope of the act, we believe, is intended to treat with a child who, 1, has not been brought before the court, 2, is subject to court proceedings, 3, is serving a sentence, and 4, is a parolee under the Parole Act who is or who was a child at the time of the grant of parole. We are of the view that the current definition of child diversion does not adequately account for all categories as outlined above, particularly numbers 2 to 4. The current definition is suggestive that child diversion can only take place before the child enters into the formal justice system, which is contradictory to other provisions of the Act. And so, Chair, we are suggesting that the definition be revised in order to take into account the actual intent of the legislation. We invite the committee to consider the definition of diversion as noted at Section 2 of the Child Justice Act 2024 of the Republic of Fiji to assist with its review. And this definition states, diversion means diverting a child in conflict with the law from the formal justice system and resolving the conflict through community-based interventions. In the alternative, where the current definition is maintained, we recommend that a definition and/or clarification be provided for the terms child appropriate process and formal adjudication. In relation to the definition for child offender, which states a child who, 1, is suspected of, accused of, charged or convicted of a diversion offense, and 2, accepts responsibility for a diversion offense as set out in subsection 4. B, an inmate who is a child serving a sentence in an adult correctional center or a juvenile correctional center, or 3, a parolee under the Parole Act who is or who was a child at the time of the grant of parole. We are of the view that the use of the term child offender is prejudicial and invites stigma to a child who is suspected of, accused of, or charged with a diversion offense. We are also of the view that an acceptance of responsibility should not be a criteria under the definition of a child offender. We therefore recommend that the provision be revisited to remove the words suspected of, accused of, charged or in responsibility for a diversion offense as set out in subsection 4 at A2. As it regards in the definition for conflict with the law, the definition states in relation to a child means taken into the custody of a constable on suspicion of having committed a diversion offense or detained or charged with a diversion offense. We are of the view that the current definition does not sufficiently capture all the stages where a child would be found to be in conflict with the law. We therefore recommend an insertion of the terms reasonably suspected of, accused of, a diversion offense to the current definition. The definition will therefore read, in relation to a child means a child who is reasonably suspected of, accused of, a diversion offense, taken into the custody of a constable on reasonable suspicion of having committed a diversion offense or detained or charged with a diversion offense. Section 2.2, which treats with factors to be considered for the best interests of the child. It is noted that the factors listed under the provision in determining the quote-unquote best interests of the child are similar to those outlined in the Child Care and Protection Act, which concerns children in need of care and protection. It is therefore recommended that the best interests of the child factors be expanded to include factors that are related to child diversion. We suggest that the following be considered to assist in drafting other factors to be taken into account in determining the best interests of a child in relation to child diversion. 1, every child is entitled to enhanced procedural protections and to be treated in a manner that is appropriate for their age and ensures that their rights are fully respected. And 2, every child must, as far as practicable, be given the opportunity to meaningfully participate in any proceedings that affect him or her. Section 2.3b, acceptance of responsibility. This section states, unless the public interest otherwise requires and subject to this act, any child who has committed a diversion offense and accepts responsibility for that offense shall be considered for admission in a child diversion program. It is noted that the terms accepts responsibility as used in the provision is also used throughout the act. However, there is no definition as to what constitutes an acceptance of responsibility by a child. And as such, we recommend that the term accepts responsibility be defined to indicate what amounts to or what constitutes an acceptance of responsibility. Section 2.3, best interests principles to be considered under the Act. We're of the view that the principles outlined under this subsection need to be expanded to provide further guidance in the approach to child diversion. We therefore recommend the inclusion of the following principles. 1, parents or other appropriate adults must be able to assist a child at all stages of criminal proceedings and, wherever possible, participate in decisions affecting the child. 2, all consequences arising from the commission of offense must be proportionate to the circumstances of a child and nature and seriousness of offense, and the child must not be treated more severely than an adult would be treated in the same circumstances. And 3, Children may only be subjected to deprivation of liberty, whether on arrest, remand, or after a finding of guilt, as a measure of last resort and for the shortest period of time necessary. Section 3, Objects and Application of the Act. It is noted that a child who is subjected to a child diversion program may suffer from stigmatization, which can affect his or her reintegration in society. We therefore recommend that Section 3 be amended to include the prevention of stigmatization, discrimination, and other adverse consequences to a child in conflict with the law or a child offender.
How would you do that, okay? I mean, I don't know how you do that. Bear that in mind.
Very well, Chair. Sections 4 to 7, establishment of the Child Diversion Office, CDO, functions of the CDO, Child Diversion Committee, CDC, and functions of the CDC. We are of the view that the functions as outlined for the CDO and the CDC are overlapping in some respects. We therefore recommend a review of the functions of the CDO and the CDC to ensure there is a clear distinction in their operations to include proper checks and balances, and the making of the regulations pursuant to Section 40 is also of great importance to give effect to these functions. We also recommend that a review of the terms administer as against implement as used under these provisions outlining the functions of the CDO and the CDC. We are also recommending that the provisions under Section 7(1)(g) and H be merged to allow for consultation on all the matters outlined under Section 7(1)(g) with the government agency responsible for children. Section 8, National Child Diversion Oversight Committee. We recommend that a quorum requirement be included for the meeting of such committee in keeping with government best practices and governance procedures. Section 9, Referral to Child Diversion Program. Section 9(1). The understanding is that the intent of the legislation is to divert children in conflict with the law at the earliest possible stage in the formal justice system. Therefore, we view that the prosecutor should be afforded the discretion to refer a child to participate in a child diversion program instead of a recommendation to the court. This is on the premise that the prosecution is at liberty to discontinue criminal matters before the court, and we appreciate that a child who is charged must appear before the court. However, in circumstances where a child has participated in a child diversion program and has successfully completed same, a child's appearance before the courts will be in an effort to have the matter withdrawn or otherwise discontinued.
If I might, that is also recommended by Jamaicans of Justice. One of the concerns which you can address later, how do we ensure, when the court put the child at diversion, the child has to come back to court so that, the question of whether the diversion or the course of conduct was appropriately addressed. So I wanted to bear in mind, how would you ensure that the child goes through the child diversion properly without the coercive power of the court? Or do you think it could be a halfway house, that if they fail to go through, you let them know they will go to the court? Yeah. So bear that in mind, okay? We can discuss that afterwards.
Thank you, Chair. The recommendation is for Section 9(1) to be amended to include that the prosecutor may refer a child for participation in a child diversion program. In this regard, we recommend the deletion of Section 9(3), where the prosecutor may recommend to the court that a child participates in a child diversion program. Where the committee is accepting of the recommendation made, an amendment to the relevant provisions in the Act would have to be undertaken to reflect such power to the prosecutor accordingly.
Thank you. Ms. Gordon, just explain to me what problem you have with the prosecution recommending to the court that the child be diverted. No, I'm just trying to figure out the mission or the object you're trying to achieve by allowing them, empowering them on a 9(1), but saying that it's not necessary on the 9(3). Because they can say to a judge, I've assessed the file, judge, I think this would be better resolved in child diversion. And a judge would accept that recommendation and then send the child to child diversion. If you can assist me with that.
Well, based on discussions, the thinking is not for it to have to go to the court to tell the judge that the child is to be recommended, but the prosecutor should be able to, at an earlier stage, refer the child to child diversion program instead of coming to court.
Sorry, is that with an understanding of what the crime was or what was committed? Is that the understanding why you say for the prosecutor to actually send the child to diversion instead of going to the court? Is that?
Chairman, I was just wondering, if we could just allow Ms. Gordon to finish her presentation. We ask all the questions at the end.
Okay.
Thank you, Chair.
Go ahead.
Expansion of Section 9(2)(d). It is also recommended that Section 9(d) be expanded to include an advocate from the Office of the Children's Advocate, and in the event of a child who is a ward of the state, a representative of the government agency with responsibility for children as persons in whose presence a child shall give consent.
CDA.
New subsections under Section 9. We are recommending that a new subsection be inserted under Section 9, to outline that where a child has been referred to a child diversion program, he or she shall not be detained in a lockup, remand center, or correctional institution similar to the provisions under Section 11(2)(d)(2). We also recommend that a provision be inserted to indicate that a child should be informed in age-appropriate language that as a prerequisite to giving consent, he or she has a right to seek legal representation. Section 13, Ineligibility of Child Diversion. This section states, a child may no longer be eligible to continue in a child diversion program or for participation in a child diversion program if the child commits or attempts to commit another diversion offense or any other offense within 3 years after the date of the commencement of a child diversion program. 2. A child shall not be eligible for participation in a child diversion program after 3 referrals to a child diversion program. Based on the wording of Section 13.1, if a child commits a diversion offense and commences a child diversion program, he or she cannot be referred to a child diversion program within the 3 years which follow such commencement. We're of the view that this is counterproductive, especially in light of the concept of the best interests of the child, as well as giving second chances. This provision runs the risk of a child not being able to participate in a child diversion program as a result of committing or attempting to commit a subsequent diversion offense within a 3-year period, and as such will not be afforded the necessary intervention during childhood. This can be as a result of being ineligible for further referrals during a 3-year period, which can lead to a child aging out. As the Act is grounded in restorative justice principles, adults who come in contact with the law do not have this limitation, and as such, we're of the view that children who more so need guidance should not be limited in this regard. We therefore recommend that the time limit as stipulated in Section 13.1 be reduced to 18 months or a more suitable period in the circumstances. We also recommend that the word referrals under Section 13.2 be changed to participation, as a child may be referred to a child diversion program and a situation arises where he or she did not get a chance to participate. Section 14, Child Diversion Program. Section 14.3 states, the Child Diversion Committee shall provide a copy of the Child Diversion Program and any subsequent modification of the Child Diversion Program to the child for whom the Child Diversion Program was developed and to the person referred to in Section 9.2d, in whose presence the child consented. We're of the view that this, as the circumstances may change in an individual's life, the words in whose presence the child consented should be removed to allow for more flexibility. That is to say, to allow for consent to be given in this regard to any person in the category, but not the initial person. For example, in a situation where an attorney at law was used and there is a change in legal representation, or where a parent was not available and now becomes available. Section 15, Minimum Standards for Child Diversion Program. This provision treats with the minimum standards for a child diversion program. The National Child Diversion Policy explicitly recognizes the significant impact of mental health, trauma exposure, behavioral disorders, and learning challenges among children in conflict with the law and child offenders. A substantial portion of these children present with unmet psychosocial and educational needs and directly influence behavior. In this context, diversion planning should be informed by professional assessment rather than assumption. It is therefore recommended that the minimum standards include a psychosocial and educational needs assessment as a mandatory component. This assessment should be conducted by a psychologist or other qualified individual supported by the state and completed prior to the finalization of the individual child diversion program. Such approach would ensure that diversion plans are individualized, evidence-informed, and responds to underlying causes of offending behavior. This recommendation is also directly aligned with the ministry's ongoing work in advancing school-based mental health frameworks and psychosocial support systems. We are of the view that integrating structured assessment into the statutory diversion process would strengthen outcomes and promote more sustainable reintegration. Section 24, copy of formal warning. Section 24 states, the constable shall provide to the child's parent or guardian a copy of the formal warning issued under Section 23, and the parent or guardian shall acknowledge receipt of the copy of the formal warning in writing. We're recommending that the prescribed form used to issue the formal warning facilitates a section which allows the parent or guardian of the child to acknowledge receipt in writing where this is not provided for standardization of the process and effective record-keeping principles. Section 26, effect of constable's warning or police caution. Section 26 states, where a constable has warned or issued a police caution to a child and that child is referred to a child diversion program, A, that child shall not be charged with the commission of a child diversion offense in relation to the facts and circumstances which formed the basis for the warning or police caution, and B, no further proceedings shall be taken for the diversion offense in relation to which the child was warned or the police caution was issued. We recommend the removal of the reference to warning by a constable in the provision on the premise that a child shall only be eligible for referral to a child diversion program by a constable after being cautioned in accordance with Section 28 of the Act. Section 28, Child Diversion Referral by Constable. Section 28(2) states, notwithstanding subsection 1, a constable shall not refer an eligible child to a child diversion committee for admission to a child diversion program unless the victim of the diversion offense, if identified, consents in writing in accordance with Section 32 to the child's referral. We recommend the removal of the requirement of the consent of a victim in the provision on the premise that a caution should flow from investigations being undertaken by a constable, and as such the constable in his or her professional capacity should determine whether a caution should be issued. This recommendation would also affect other provisions under the section which make reference to the issue of consent of a victim. Section 33, warning, etc. by the court. Section 33 states, Where a child is charged and brought before a court in respect of a diversion offense, the court may A. hear the case, B. issue a warning to the child and suspend the prosecution of the case if the court is satisfied of the matters set out in subsection 2, C. refer the child to the Child Diversion Committee for the parish in which the child resides for participation in a child diversion program, or D. adjourn the case sine die. The recommendation is that section 33(1)D be deleted on the premise that such indefinite adjournment run the risk of a child being quote-unquote lost in the system. It also contradicts the principles of the best interests of the child, as well as the spirit of the act, which includes a matter being treated without undue delay. It also goes against the overriding objective of the judiciary, as well the principles of differentiated case management, which is otherwise referred to as DCM, in having matters dealt with expeditiously, judiciously, and with the requisite sensitivity. Sections 34 to 36, court orders, reparation order, and order to make amends. Sections 34 to 36 make reference to a child in need of care and protection, and in light of the object of the act being that of diversion, we recommend that these references be removed. Also, in keeping with our recommendation that the definition of child offender be amended, a child offender under these provisions would not be alleged to have caused physical injury to any person or loss or damage to any person as the offense would have been proven. We therefore recommend that the provisions be revisited to include a child in conflict with the law together with child offender under sections 35(1)A and 36(1)A, as well as the matter of the offense being alleged as well as proven under section 35(1)B and 36(1)B, as the case may be. Also, in light of the removal of the reference to a child in need of care and protection, reference to a children's officer, under section 35(1) and 36(1) would need to be deleted. This is on the premise that children's officers, as per the Child Care and Protection Act, would only have jurisdiction to act in circumstances where a child is deemed to be in need of care and protection. Section 38, suspended sentence order. Section 38 states, the court may make a suspended sentence order if the court is satisfied that a child having been referred to a child diversion committee for participation in a child diversion program under section 34 has completed the child diversion program in respect of the diversion offense for which the child had been convicted and sentenced. The recommendation is that the provision be deleted as similar provisions exist under section 11(2)D and section 34(2)E of the Act. Section 40, regulations. We recommend that regulations, Chair, as a matter of urgency, be made to adequately assist in the effective operation of the child diversion programs and connected matters in the different parishes. The first schedule, diversion offenses. We recommend the inclusion of the offense of grievous sexual assault pursuant to section 4 of the Sexual Offences Act under paragraph 1 of the first schedule of the Act. This is on the premise that, similar to the offense of indecent assault, grievous sexual assault is an either way offense, which means a child can be tried at the parish court level or the Supreme Court level. And it's also noted that a lot of grievous sexual assault matters have been coming before the court for treatment in respect of a child. General comments. Reasonable suspicion. We recommend that where there is any reference in the Act to any form of suspicion, same be qualified as reasonable in keeping with legal principles. Children with special needs. We recommend that a provision be included under the Act to cater for a child who is or appears to be suffering from a physical, intellectual, or mental impairment and is found to be in conflict with the law or who is a child offender. We suggest that in such situation, the provision indicates that due regard be given to the Disabilities Act. Further, in circumstances where the child is or appears to be suffering from an intellectual or mental impairment, we recommend that the child be assessed prior to any action being taken against him or her. Strengthening the education interface in the Act. As we are aware, the Act is principally justice-led in structure and administration. However, in practical terms, the long-term success of diversion is determined not solely by avoiding prosecution, but the child's reintegration into structured developmental pathways, most critically, education and skills training. Diversion that does not deliberately reconnect a child to some form of learning risks becoming a temporary solution rather than a meaningful rehabilitative intervention. Many children who enter the diversion framework are already disengaged from school. In such cases, addressing the offense without addressing educational exclusion may inadvertently increase the risk of recidivism. The recommendation, again, Chair, that the regulations be developed under the Act requiring every child diversion program to include a mandatory educational continuity assessment. This assessment should inform a structured reintegration pathway tailored to the child's needs and circumstances. Such a pathway should include reintegration into one of the following: formal secondary education, a skills-based track through the Art and Estate Trust, or an approved vocational or alternative education program. Embedding educational reintegration as a formal component of diversion, we believe would strengthen the rehabilitative intent of the Act and align the child justice framework with our own national youth development and skills strategies. And last but by no means least, time limits. A child-centered justice framework must also be timely. Administrative delays can undermine both rehabilitation and the best interests of the child. It is therefore recommended that statutory timelines be introduced via regulations for key stages of the diversion process, which include referrals, the minimum number of meetings within a specified time frame of a child diversion committee, and consideration for approval of a child diversion program. We're of the view that clear procedural timelines would promote efficiency, reduce backlogs, and ensure that interventions occur while they remain developmentally relevant. In the absence of such safeguards, the rehabilitative impact of diversion may be diluted by undue delay. Chair, this is our presentation. Thank you.
Okay.
We may take questions. And sir, let me just indicate that my team members will assist in answering, especially from the CPFSA, as they are directly involved in the operationalization of the Act.
Not a problem. I know other members will have questions. Just to thank you, for the work that you did in analyzing the act itself and the suggestions for amendments. While you were speaking, I recognized that usually at the end of all the presentations, the Parliament and our team do a matrix so that we are able to look at the suggestions as to what suggestions have been come. Like, for instance, the recommendation coming from, say, Jamaicans for Justice and yourself, that it should even go to the court. Once it comes to the police and the charge, maybe you deal with it there. One thing, though, that the CPFSA can assist us with, because these children are coming to us, many of them maybe haven't gone through your program, whatever your program involved. So we're getting them, should I say, a number of the kids who come to us and the child diversion program may well have been through actual programs that you may be conducting. And one of the things I've always wondered is how we can collaborate better to ensure that when they're going through CPFSA, that you don't wait until they commit an offense before they come into our program. Because certainly you people will know, I don't want to use any term, but the troubled child who needs assistance then and there. And to the extent that when I spoke a few meetings ago, we can find greater collaboration with CPFSA, where a child is imminent that they're going to get into trouble. You know, how do we stop and intervene before they actually get into trouble? So we will discuss that further, but let me allow some questions from the members, and I know since Senator Golden Campbell has her hand up. So, Sherry, will you go ahead and ask the question?
Yes, thank you, Chairman. I'm going to probably ask one or two questions at a time, yield, and then if there's time, I will ask my remainder questions. Just want to congratulate the team from the Ministry of Education on their presentation. I found it really, really quite comprehensive. I was struggling to keep up with you because I was going between my acts and what you were saying. But it was well done, and thank you for that. I want to say in relation to your recommendations on section 2.1 on the definition of child diversion and the definition of child offender, that you have my attention, and I look forward to our further deliberations in committee on the matter. But I want to turn to your recommendations in relation to section 9, in which deals with referral to a child diversion program, and in particular your recommendation of the new subsection to outline that where a child has been referred to a child diversion program, he or she shall not be detained in a lockup, remand center, or correctional institution, similar to the provisions under 11.2d2. Maybe I haven't been understanding, but is this happening now? I didn't understand that a child who had been referred to a child diversion program was at any point in a lockup.
It's quite possible, Senator Golden Campbell, because especially if they're charged with an offense, I mean, they shouldn't, and really and truly they shouldn't. But to the best of my understanding, the police detain them until they take them to court. Is that my understanding? Is that your experience? So the answer, it is unfortunate, because we have always felt that once a child has committed an offense, we really should find a way to keep them out of the formal system.
Yeah.
So
and thank you for that, Chair. I wonder though, what is the ministry's experience of that now? What motivated this recommendation that you made?
Maybe you could give us some.
Well, they made a recommendation. I'm assuming there's a
directly. Right.
Good afternoon, everyone. So from our experience, what we've seen is that there are some courts that, particularly the children's courts, that when the children are referred to the program, some of them are sent to juvenile detention centers during the period that the program is completed, and when the program has been completed, that is when they return before the court. Some courts do interval sessions with them. They appear before the court at various intervals, but many of them, what they will do is that until the program is finished, they remain in the juvenile detention centers. If they have successfully completed the program, then that is when the court will
You're
discharge.
talking about the child diversion program?
Yes, sir.
But
Yes.
Lanisha, is that the experience of the officers? I mean, I thought if the program is going on, they're not detained. It is before the program starts that they're detained. But
Minister, unfortunately, we do have some of those cases where the child is in remand, and it poses a challenge for us as well, because if we're providing them with interventions for rehabilitation and we're leaving them in an environment that is hostile, for lack of a better word, it is challenging. And even, let's say, the part that you like, the mentorship and so on, to get a mentor to go into that facility will be a challenge as well.
Yeah.
but
Actually, I have another question
Sure.
in relation to section 13. And the team said that they were taking issue with the time period under section 13 of 3 years, where if a child had committed a diversion offense and commenced a child diversion program, they couldn't then be referred to the child diversion program within 3 years. I'm assuming in the event that they committed another diversion offense or were accused of another diversion offense. And the team has buttressed their recommendation in respect of that section by pointing us to the concept of the best interests of the child, the need to provide for second chances, etc., etc. And so I want to ask the team, given the basis on which you made this recommendation to reduce the time from 3 years to 18 months, and your reasoning, wouldn't it then make sense and wouldn't it then be more consistent for you to be recommending that time be removed altogether? And I would love to hear you opine on that, but I would also love to know what, if any, research would you have done, what would your research have uncovered in relation to the interplay of the best interests of the child and this concept that a sort of strike one, strike two approach to them in terms of their access to a child diversion program?
Go ahead. You want to, Mr. Chambers, you want to respond?
Yes, Mr. Chair. We looked at it and we discussed totally asking for its removal, but in the absence of the committee not saying remove the 3 years, at least a year or 18 months. Because if you're saying a child commits a diversion offense today, starts the program, and somewhere along the line another offense is committed, and you're saying you cannot access until 3 years have passed, it allows for the fact that the child would have aged out. The ability to go back on the program. If it is that it is to divert a child and give a second chance and go to court.
And I think what Senator Goldenkamp is suggesting, remove the time period.
Precisely.
So that whoever the child diversion officer or the court or the police can say, should the child continue on the program or, be dealt with, So I think
if I could just
sure.
If I could just extend my question a little bit, Chair, because my concern is not even so much the question of aging out. It's a question of what is in the best interest of the child and what is the research and the data around how you treat with children who are engaging in inappropriate behavior and committing offenses like this. And I know, we're talking really about non-violent offenses to a large extent. But if a child has participated in the program and they can't participate in another program for the next 3 years, just as a mother, it's counterintuitive to me. I can't think of any one thing I teach my children that they observe the first time around. Parents know that we normally have to repeat and repeat and repeat and repeat and repeat and then repeat some more before we get our children to comply. So if we're looking at a diversion program buttressed by this act, then can the team comment on, this concept of this 3 years? Because you went halfway down, and I'm just not getting that. I mean, I think when you come to speak to us in Parliament, ask for what you want. I don't think you should anticipate what we may say in terms of no. Do your compromises after that, because you have me confused now as to whether there's a real issue in terms of the best interest of the child, or whether this is just about aging out or timing out.
And indeed, I think Senator Goldenkamp is the point. Really, is what should be determined is whether the child can benefit from the child diversion.
Yes,
so
Chair.
if they did one and they succeeded, the likelihood is that they may benefit. If they fail, the likelihood they may not benefit, and therefore they shouldn't go on the program. But to put in place a time period, I think I agree with you, Senator Campbell Golden. There should be no time period. So, Julia, make a note of that.
Chair, with the indulgence of yourself and my colleagues, I have a last question in relation to the first schedule, diversion offenses, when the team recommended the inclusion of the offense of grievous sexual assault, which I must say is a recommendation that startles me because of the nature of the offense of grievous sexual assault. And I just would love to hear the justification for this recommendation. So if I could put those two in tandem, I'd be grateful. And with that, Chair, I will yield.
Go ahead, Ms. Chambers. Ms. Blackwood answer.
Very well. This actually stemmed from a stakeholders meeting that we had the other day in a particular parish where we were discussing with the senior family court judge the nature of the offenses that are before the court currently. Sisoka was also involved in that meeting, and what we have found is that there are a lot of children who may be experimenting, right? They may be experimenting, and those children are brought before the court. Remember that grievous sexual assault, it does require some form of insertion, right? And because it requires that insertion, there are children, again, who in experimenting, they do these kinds of things. And with finger, with anything else, right? Now, in terms of the inclusion of the grievous sexual assault, we see here under the first schedule that we have sexual intercourse with a person under 16, right? We have indecent.
And that is why so much of this act needs to be clarified. Because the court is of the view that accept responsibility means pleaded guilty. And I'm glad you've come up with that for us to say exactly what accepting responsibility means. Because across all countries, the idea of child diversion or child justice is to keep youngsters out of having a conviction if they can go straight after a period of mentoring, so that they don't get a record. You see, so we need to look carefully at how we can do that. I like the idea that the prosecutor could recommend a child diversion, and so it doesn't come before the formal court. I mean, a constable is likely to charge. So it then would, and Mr. Nash, remind me, we're going to ask the DPP to come, and those clerks of court or Crown Council who have dealt with child diversion, how they feel to be one of the referral officer who can refer matters before it actually comes to the court. There's no doubt that in many cases, maybe even in this grievous sexual assault, they might not want to make a decision. They might want to put it to the court and make a recommendation so the court can do it. So, but for some minor offenses, as you and Jamaicans the justice have recommended, it might make good sense for the prosecutor to go to child diversion, and after 3 months, 6 months, they can withdraw the charge. If there's a successful program, there's no successful program, we're going to take it to the court. All right, so that's something we're going to look at. I think Member Buchanan went first, unless he yield to you. Okay. All right.
Chairman, it's happening in real time and over and over and over. That proposals are here because so often right now you have cases in the courts with sexual offenses between consenting, and the complainant doesn't come to court for 12 times, and then the court goes through a lot of hassle with the police to send them out, find the mother, you don't find the mother. The parents have moved out of the way, they recognize the situation, and they go again, and whereas the court says they want to finish the matters quickly and justice is timely, not so with these. And I have heard crown counsels in court say that, and I have heard the court sit and hold that matter over a child's head for over a year, waiting for the complainant to come out. And finally, in some of the cases, when you have officers who are good female officers from Sissoko, and they will come forward and then say to the court after it has gone on for over a year, Lord, we really have made the year.
And that's when it is discharged.
It is happening in real time over and over and over again.
I think you will understand, Mr. Chung, why this consensual sex between oftentimes neither of the party obviously want to turn up in court. But the court, because it is a crime, the court has to due diligence ensure that the matter comes. And I think as Member Dalrymple has pointed out, many times the parties are saying it's consensual, we don't want any parties to do anything with the court. And that is why the suggestion that the prosecutor can make a decision before anything happens. Again, colleagues, you don't know this, or you know it. We have a problem with teenager consensual sex, and maybe non-consensual sex. Just 2 weeks ago, I was addressing about 60 pregnant teenagers, where we brought them to talk to them about their rights and responsibilities. And I must admit, it shocked me, Minister Dixon. It shocked me that they were there at the hotel, I won't say which hotel, and we treated them so they could get legal advice from the Legal Aid Council, get advice from a number of agencies. 60 of them we were addressing, and I was shocked at the level of teenage pregnancy in this country. Very sad incident.
I am saying that I'm an attorney by profession, and I was totally unaware of how much effort, how much time, how much money has been spent by the ministry in helping to rehabilitate and to treat these people properly. So again, Minister, I'm urging also that, and I'm saying this as an attorney, that the ministry needs a proper PR company so that everybody knows what the services are, because it's happening and so many of us are not aware.
But in this case, especially of consensual sex between teenagers and teenagers getting pregnant, It's a wide-scale problem that member Buchanan.
Member Cuthbert.
He had yielded to one female person.
But I don't mind yielding to the goodly minister.
You like yielding? Okay.
I don't mind. I will yield to the goodly minister.
Minister Conversion.
I just wanted to clarify something, and I think this conversation is really good to have. Also, to have this committee set up. I was listening to many of the recommendations that the Ministry of Education put on the table, and for one of them recommending that the child, as far as a prosecutor is concerned, that the prosecutor would make the recommendation before the child goes to court. You did mention also Miss Venicia, about some of the children who are in correctional facilities, and that is a fact. And I think that is one of the reasons why we're here, also to make sure that doesn't happen, where the prosecutor can actually make that recommendation before. And I think what we need to solve is, where do we put those children before, once that recommendation is made, in order for them to get the care. You mentioned a possible hostile environment that they may be in, and so I had to turn on my mic. And yes, there are case managers. We do try to make sure that those children who are sent to the facilities, the correctional facilities, are not so much in a hostile environment. So I wanted to clarify that, and that there are case managers. We have some of the best case managers actually at Ministry of National Security and Peace, to make sure that they are getting the skills training, that they are following up with their education while they're incarcerated, while they're there in the facility. However, I think it is important that we solve this issue so that these children are not sent to the correctional facility because they do not belong there. Most of them, I guess, they're deemed uncontrollable. And so I don't think it's an ideal place for them to be in that space. And so, I hope that while we're here mulling through, that we can come up with really good solutions for where those children can be placed before they're sent to a diversion.
Thank you, Minister Conversion. Member Bucket.
Thank you, Mr. Chairman. I just want to go back and use the benefit of Mr. Chung, who is here, in relation to the time reduction of the time that a child is barred from access to child diversion. In a simulation aspect, Mr. Chung, dealing with a mentee, what would be your thought if while you're the mentor, he comes back and says, a little stabbing took place, a little sex took place here.
What would be in the message?
So I thank you for that, Mr. Chung, because I'm happy that the ministry has said that we were just trying our luck for reduction. I'm taking this opportunity to put on record that I support that the time limit be removed, because that's the spirit of the best interest of the child. That is so. Now, the issue of, first, let me just say that your recommendations are well thought of, and I must commend you on that. I would say if we had the chairman wants more weeks with this, but
you mean
we could just stop today, but I'm holding this close. I must say that. I want to speak though, and just permit me. The recommendation about the grievous sexual assault. It's a very hot topic, and that's why my mic was on. It's really a by the way offense when it comes to underage sexual activity. In fact, a true question would be, it it's kind of difficult to see how there is consensual sex between minors, but there's no consent to the experiment from the digits or insertion by objects. But my question is, if we push the handle a bit further, when it comes to child, in situations where a young man or, well, I can't even say the young woman, a young man, based on the definition of sexual offense, if the young man is not getting the indicators of the yes or no, he's found in the category of rape. Should he be excluded from child diversion for not being able to understand indicators when adult males are
non-consensual?
No, well, the non-indicators is for a child we're hearing not understanding the no's from there's no no, so there's no indicator of no. I'm just saying, in a situation where there's no consent, I'm not pushing it. I'm just wondering if the thought is that when it comes to the best interest of the child, that we're doing corrective measures, and if there is possibility of an expansion. So I'm looking for a response, and I know there are two lawyers there as well. Help me out here.
No, you want to go first? All right, go ahead, Ms. Chambers.
So, from our experience, and the suggestion comes up where you have, Mr. Chair, you have 15 females in South Camp of having sexual, quote unquote, consensual, finger-related matters with each other. How you treat with these young ladies? Should they be eligible for diversion? Should the family court, be able to look at those matters, look at the circumstances, and decide what is to happen, rather than be totally excluded? Because what you will then have happen, matters get sent to circuits, all that way, all that trial, where the court may refer, okay, child diversion, when it could have been dealt with much earlier. So what we see happening is a lot of young ladies, experimental, consensual, if you want to treat it with it, that matter. But how is the judiciary supposed to treat it, the family courts? That is what we're asking for. Allow the court to have a discussion, look at the nature of the circumstances between those matters and treat with it, rather than total exclusion of grievous sexual assault.
All right. I want to ask that question, but let
I wasn't quite finished as yet.
Sorry.
I apologize, but it's just I have more. So your section 26, that is the warning from the constable. There was a recommendation that reference to warning be removed. And my question to you is, why I strongly disagree with that, and I wanted to know what was the reasoning behind section 26, the effect of the constable by the warning. Because the warning from the constable actually empowers the constable in his wisdom to simply say, correct yourself, and you don't need to be diverted. So if somebody can just direct me.
In other words, it's preventative rather than
right. So a constable in his wisdom would basically say that this is something that can be handled even outside of, without even, right.
In other words, if they comply, then there's no need to go further.
That is so.
Sorry, you wanted to follow up on that?
No, I just wanted to get an answer, I guess, with the new subsection under section 9. When you mentioned your recommendation, subsection 9, to outline that where a child has been referred to a child diversion program, he or she shall not be detained in a lockup, remand center, or correctional institution. What do you suggest? Is this when the prosecutor comes in to make that recommendation to say the child will then go to child diversion instead of going to a remand center?
Go ahead, Ms. Chambers.
I think we said flat out, if a child is sent to the child diversion program, should not be kept in custody for the purpose of a diversion program being continued. So you've been referred. If you're in a correctional facility, you are being sentenced twice, more or less. You have been sentenced and on the program. So no correctional facility whilst the child is on that program.
Thank you.
Dixon, I still didn't
Thank
answer
you,
my
Chair.
question as yet,
She
but
just
I-
want to
I-
intervene on that.
I was going to intervene on that one, and team, you know that I think you're great. Anna, thank you for the presentation, and I know you did a lot of work on this. But I just wanted to add something to what Minister Cuthbert Flynn would have asked. We're recommending that they do not be placed in any correctional facility, but we do recognize that there are some children who do need additional support. And so what we're doing right now is starting to repair some centers. So under the CCPA, there is reference to therapeutic places of safety and therapeutic residential therapeutic centers. So students, children who may have emotional issues or other psychosocial concerns and need more support, we're actually putting in place facilities for those children, because some children may not be able to go back home. And so it's important that the work, and so that's where we have to dovetail with each other. So you have child diversion, but the CCPA Act is also kind of looming in the background too. And so we have to ensure that everything is working in tandem. So we're making this proposal that they not be put in any correctional facility, while also at the same time saying that we're expediting the work on the residential therapeutic centers.
Continue.
Well, I was still waiting on the answer. Okay, they're ready for me.
So as we have indicated in our recommendation, if you look at section 28 of the Act, which speaks to child diversion referral by a constable, the referral can only be made if the police issues a caution. So in this provision under section 26, it says where a constable has warned or issued a police caution, and that child is referred to the child diversion program. So if you dissect it, it is saying that the child can be referred to a child diversion program by a constable upon being warned, but the Act doesn't provide for that under section 28. It only provides for referral on the basis of a caution.
Okay, right, but so I see that, but the warning, the warned aspect of it is he has the power to warn and nothing would be further. It's just that the legislation speaks of warn or caution.
Do you interpret it that way?
Right, that's why I want to know if it was interpreted that way, because his power to warn just simply means that stop doing what you're doing and no further action. So this section 26 speaks about warn or caution. So there, it seems to be an overlap, but it's actually functioning the way it's supposed to function. That's why I was wondering, because you had recommended that it be
that warning,
right.
the word warned be
right.
removed.
Yeah, but the warning is saying the constable has the power to warn, and when he warns, no further action takes place. That's the usual course, the power of the constable.
So what I think Member Buchanan is saying is good. We need to ensure that the use of that section is preventative and not a preliminary tool to the next.
That is so.
Well, maybe the drafters can relook it to
okay, I just was thinking
reconstruct the drafting for it to be clearer that there is no misinterpretation. Because if we are interpreting it like that, that means it might be interpreted otherwise.
Very well. The section 28 now, which I agree with you 100%. Just asking if there was any conversation of the same child diversion referral by constable and the removal of the need to the consent of the victim. I agree with you. Just was wondering if you contemplated anything in relation to victim services, in light of the fact that you're not looking for the consent if you look for victim services to assist the victim. To say there's a forum and that's why we don't require consent. Just asking if you guys consider it.
You agree with that? Okay.
Okay. Now, in section 33, which is warning by the court, agree with you again in relation to adjourn the case. Cyanide, that's the D. the effect of B, wouldn't it be the same, issuing a warning to the child and suspend the prosecution of the case if the court is satisfied of the matter set out in subsection 2?
Right. So you want both removed?
No, I'm just, I would want both removed, but I'm just wondering if you want it kept there for any reason.
What I think is important, 2 really should be until if the child goes through successfully, right? And then you know, as you have pointed out with D, you don't want something to be hanging over and that get lost.
That is so true.
So you want 2 to be where you suspend the prosecution until the program satisfies or fail to satisfy, and then you come back to 2 to either continue with the case or dismiss it. So that is a matter for us to look at an adjustment to the act in 2 to avoid D, in B to avoid D. So that you suspend the prosecution until the child has gone through the diversion program.
That is so right. Now, just going to section 38 and raising this in the context that we're talking, there's some issue with how children are treated. And Chairman, I'm just raising this for you because there are minor offenses where if adults commit them, they will get station bail. But once it is the minor, the Child Care and Protection Act kicks in and they're held. So I think there's an overlapping of legislation that will have to make the to strengthen child diversion, and the act says it, but just to look at that, because I think that I'm hearing that children are kept in state care because of the committing of the offense, and I think that's something we should look at. But section 38, and it's speaking about the suspended sentence order. In reading the legislation, I see you're saying that it is an overlap, but I'm noticing that the suspended sentence order is actually contemplating a child who didn't go through child diversion, and it seems to be a review mechanism, because if the child is at one of the pleasures of the state minister's institution, then a review seems to suggest that if the child is put on child diversion program and it's sent and is successful, that sentence may be reviewed as in suspended or set aside immediately, and the child is released. So I'm wondering if you looked at it that way, because asking for this suspended sentence order to be removed, it may prove problematic.
You see, one of the concerns here, Member Buchanan, is that if this act, which is the failure of the ministry, was reviewed 3 years ago,
we wouldn't be
in this position.
That is so.
Because the truth of the matter is that the act did contemplate that there may have been persons who were in custody
already. Right, that is so.
And that you were going to assist them with child diversion, or who in fact maybe have committed the offense as a teenager
and just went over the threshold.
And just over the threshold going through parole. So the truth of the matter is that we need to have the final version where we try to avoid any child who has committed an offense during a relevant period not getting a conviction.
So that we wouldn't have to contemplate this. But as it is right now, Chairman, it operates as an ability to reverse that conviction and sentence.
You see, we're trying with child justice across the world to understand that children are at the stage where they do get into trouble, but you want to divert them away
from
and to go straight, and you do as much as possible. Obviously, there are cases where you can't help, but you must do your very best to make sure the child goes straight.
Thank you.
Just one last thing, and I just want to. I'm happy to hear, Minister, what you mentioned, and I'm hoping that this center, is it that something is in train now? So because once we amend this, I think it's going to be important to make sure that the center is ready, so that, because let me just state that a lot of these children, maybe the parents, maybe the families don't even want the children there. And so it's going to be important for them to be able to go somewhere, um, while this diversion is happening, while the mentorship is happening. Um, and so it's going to be very important, Minister, that this center is ready so that some of this pressure can come off of my back.
Yes, Chair, through you, Chair. Minister, it is in train. We have identified the location. So right now we've approved the spend to fix it. So it's pretty advanced. And I want to thank the CPFSA team and the Ministry of Education building team for supporting on this.
Good. Thanks. We're almost at the end, but one of the things I would like to say is CPFSA and Minister, and the Minister is overall responsible for children. I find that we're not working closely together enough. Because when I listen to you, it's clear to me that, Child Diversion, Children's Advocate, Sissoko, there could be better collaboration. You understand? We seem to be working at different levels. Because, as I've said before, somewhere along the line, child diversion, we need to find a way for child diversion to kick in before the child goes awry. And, I think the child diversion officer, Mr. Levis, mentioned a case where, in fact, a parent and a child were total loggerhead. And the parent, apparently, the child actually was referred to child diversion, maybe after committing an offense. They got back so close after the diversion mentoring that the mother, as he explained to us a few weeks ago, actually came and thanked the child diversion mentorship for bringing her child and parent back together. And, I suspect you have a lot of this. And one of the things why I suspect the court might refer some offenders to the safety institution is because the parent, they can't get along with the parent, and the parent just don't want them in the home. And we need to find a way for that mentorship to bring back the child. I mentioned that situation because the mother was so happy. She wrote letters and went and visited the child diversion office to thank the program. And I'm saying these are matters which, if we work closer together, because I'm sure in your CPFSA, you have situations like that where the child and the parent just not getting along, and that's why you have to be dealing with them. And to the extent that child diversion could assist them, or we need to look at those to work closer together. Yes, ma'am.
There's also the aspect, while we're looking at the children and helping them, that there is a responsibility for a parent, for someone who has a child. And there are a lot of parents, there are a lot of fathers who are absent. There are a lot of situations where I think we have to somehow take into account the parent who doesn't care. I'm not talking about the young child or young parent, but there are so many adult parents that are not accepting their responsibility as parents. The children get into trouble and we focus on the children. I think somehow we have to capture the responsibility of our parents.
All right, I'm going to thank members from the Ministry of Education. I don't want to let you go free totally. I want you to continue to participate. If you want, you can come and listen, or you can listen virtually. But maybe when the committee starts to deliberate, we might want to question and clear up some of the points, because we're hoping by April we might start the deliberation as to some of the improvement to the act. And we want to thank you sincerely for all your input. But you please, Sissoko will be coming, the children's advocate will be coming Ministry of National Security, JCF will come in, and I'm hoping to invite the DPP to come. So I hope you follow the proceedings as we meet. I think we're likely to meet again on the 25th, the Wednesday at 2 o'clock. So I ask you to follow, and if you have any input, either to your minister or directly to the Secretary, Mr. Natch, please convey to any input you may have. But I want to thank you for the presentation and also for the hard work you put in getting this paper out. I'm going to ask Mr. Nash to circulate it to future presenters so that we don't duplicate. They can say they adopt some of the things here rather than going over and over the same point. So, Mr. Nash, those who are coming, like Sissoko, we can send a copy to Sissoko and also the Children Advocate and MNS, whoever is coming from to make the presentation, and probably even to the DPP when I ask her, write her formally to send some Crown Council to make presentation. So I want to thank everybody. You want to say,
Mr. Chairman, I wanted to just indicate that there is a collaborative effort that takes place with, especially on the parish level. So members of the Child Diversion Committee at the parish level includes our friends from DCS, members from the JCF as well. We have CPFSA, we have guidance counselors, education officers, psychologists, people who are able to understand the child from all aspects. So we do collaborate. So every parish committee has a member from all the entities.
Thank you, Mr. We're going to close off, but before I close off, please, colleagues, we had indicated to you that if you think of any specific stakeholder from the list that you would like us to invite, even if you don't do so now, you can so indicate to Mr. Nash. And also, we need to we are going to the hybrid. We're going to get that. Okay. And okay, so just one or two other matters. The Jamaica Council of Union of Churches, they are going to review their submission, and I certainly hope if we send copies of these presentations, Jamaicans of Justice, and so on, that they can reduce those who are coming later, Mr. Nash. Let them know these are presentations that were made. If they agree with aspects of the presentation, they don't have to repeat it. They just can say, I agree, or disagree, as the case may be. Remember, we want to know, colleagues, we need to just do a general thing.